Ready, be ready, start. The Learned Council for the Appellant has placed reliance on the case of Mohsin versus Reshma full stop. In this case, the High Court had set aside the order of the civil judge granting the custody of the child to her mother's paternal aunt while the father was not proven to be unfit full stop. However, the High Court of Rajasthan held that in the light of Section 19, which bars the court from appointing a guardian when the father of the minor is alive and not unfit full stop, the court could not appoint any maternal relative as a guardian full stop. Even though the personal law of the minor might have preferential custody in her favor full stop. As is evident, the aforementioned decision concerned appointment of a guardian full stop. No doubt, unless the father is proven to be unfit, the application for guardianship filed by another person cannot be entertained full stop. However, we have already seen that the question of custody was distinct from that of a guardianship full stop new para. As far as matters of custody are concerned full stop, the court is not bound by the bar envisaged under section 19 of the act full stop. In our opinion, as far as the question of custody is concerned, in the light of the aforementioned decisions, the personal law governing the minor girl dictates her maternal relatives, especially her maternal aunt, shall be given preference full stop. To the extent that we are concerned with the question of interim custody, we see no reason to override this rule of Mohammedan law, and hence a prima facie case is found in favor of the respondents full stop new para. Further, the balance of convenience lies in favor of granting custody to the maternal grandfather, uncle, and aunt full stop. A plethora of decisions of this court endorse the proposition that in matter of custody of children, their welfare shall be the local point full stop. Once we shift the focus from the rights of the contesting relatives to the welfare of the minor children, the considerations in determining the question of balance of convenience will differ full stop. We take note of the fact that respondent number 2 on record has stated that she has no intention to get married, and her plea that she had resigned from her job as a technical writer to take care of the children remains uncontroverted full stop. We are hence convinced that the respondents will provide sufficient love and care for the children till the final disposal of the guardianship application full stop new para. A dispute arose between the parties and matter was referred for arbitration full stop. Due to some reasons, arbitration proceedings were not concluded full stop. Respondent filed application before the High Court seeking removal of the arbitrator full stop. High Court directed appellant to appoint a new arbitrator and further directed the arbitrator so appointed to conclude the arbitration proceedings within 6 months full stop. After the expiry of 6 months, both the parties extended the time to conclude arbitration full stop. The arbitrator failed to establish the award within the extended time full stop new para. Respondent filed application before High Court for a declaration that the mandate of the arbitrator stood terminated full stop. A perusal of arbitration agreement revealed that the arbitrator had power to enlarge the time to make and publish the award by mutual consent of the parties. Full stop. Therefore, without the consent of both the parties to the dispute, arbitrator had no power to further extend the time beyond that which is fixed. Full stop. It is an admitted position that the respondent did not give any consent for extension of time. Full stop. Thus, the arbitrator had no power to further enlarge the time to make and publish the award, and therefore his mandate had automatically terminated after the expiry of the time fixed by the parties to conclude the proceedings. Full stop. Arbitration is an efficacious and alternative way of dispute resolution between the parties. Full stop. There is no denying the fact that the matter of arbitration had evolved over the period of time to help the parties to speedily resolve their disputes through this process, and in fact the Arbitration and Conciliation Act recognized this aspect and has elaborate provisions to cater the needs of speedy disposal of disputes. Full stop. The present case illustrates that, in spite of adopting this efficacious way of resolving the disputes between the parties through the arbitration process, lingered on for a considerable length of time, which defeated the notion of the whole process of resolving the disputes through arbitration. Full stop. The contention of the appellant therefore cannot be justified that, since the dispute was highly technical in nature, it had to be dealt with elaborately by the arbitrator, and that he was justified in being late. Full stop. High Court correctly fixed the time for the arbitration to be concluded within a period of 6 months from the appointment of the fourth arbitrator, and considering the time that was spent for the arbitration process prior to his appointment being a technical and complex issue. Full stop. New para. Even assuming the arbitration process involved a highly technical and complex issue which was time consuming, even then it was open for the arbitrator or for the parties to approach the court for extension of time to conclude the arbitration proceeding, which was not done either by the arbitrator or by any of the parties. Full stop. As correctly noted by High Court in its impugned judgment, there was no cogent reason for the delay in making and publishing the award by the arbitrator. Full stop. He already had the relevant material at his disposal and could base his findings on the observations made by the 3 arbitrators who were appointed prior to him. Full stop. New para. It has been correctly observed by the High Court that the arbitrator had become funcus officio in the absence of extension of time beyond 13 September 2005 to make and publish the award. After the said date, the arbitrator had no authority to continue with the arbitration proceedings. Full stop. The learned counsel, appearing on behalf of the appellant, argued that in the absence of any statutory period prescribed under of the Act for rendering an award, the direction of the court to conclude the arbitration proceedings within the time prescribed by it would not make an award passed beyond the time so prescribed null and void. Full stop. He further argued that the High Court was wrong in not extending the time fixed by it in the order for early conclusion of the arbitration proceedings and terminating the mandate of the arbitrator when neither the Act nor the arbitration agreement prescribed any time for making and publishing the award. Full stop, new para. So far as this decision is concerned, we may keep it on record that this decision was rendered under the Arbitration Act of 1940 and not under the present Act, which we are only concerned. Full stop. In view of our reasoning given herein and in view of the facts involved in this case, we do not find any ground to rely on this decision of this court for the purpose of the case. We have carefully gone through para 8 of the decision relied on by the learned counsel for the appellants. We may not forget that we are concerned in this case with the Arbitration Act 1984. Without going into the details of this decision, we may simply say that this decision cannot have any direct application. Full stop.